Hear ye, hear ye, hear ye. All persons have anything to do for the Honorable Justice of the Appeals Court, now sitting in Boston for the Commonwealth, draw near, give your attendance, and you shall be heard. If I say the Commonwealth of Massachusetts, court is now open. Please be seated.
Thank you. Good morning, everybody. Welcome to the Appeals Court. This is our first session for November. Can you believe it's November of 2025? And your panel today is me. I'm Greg Massing. To my right is Justice Hand. To my left is Justice Allen. We'll be your panel today. We have read your briefs. We've read the record. We're very familiar with the cases. So you can jump right into it, as you know, or in case you don't. 15 minutes per side, no rebuttal. It's your time. You're free to use it all. But there's no penalty for finishing early. We have all the materials are on these handy little tablets here. So if you see us looking over here, it's not because we're looking at the Patriots game or the World Series, but we're looking at your materials. I think that's all for the initial announcements. And again, we've read the materials, so you can just jump right in. We usually take a break around 11 after about 3 cases. So those of you who are here for later cases, thank you for being here. But if you're not being called until 4th or 3rd, you can feel free to go out into the hall or whatever. So the first case, if I've got it right, is 24P580 Commonwealth versus LASSITER-FRANKLIN.
Good morning. May it please the court, Joanna Sandman for Dennis Lassiter-Franklin. The Supreme Judicial Court's decision in Commonwealth versus Quentin Smith is dispositive for this case. The Commonwealth versus Quentin Smith essentially states that where the Commonwealth did not provide substantive evidence that the defendant's date of birth, there's insufficient evidence to believe that the defendant was not licensed to carry a firearm. And the facts in this case are even more compelling than in Smith because we have both a date of birth issue as well as a name issue. So in this case, there was no evidence that the date of birth that was used in the search conducted by the CJIS witness was in fact Mr. Lassiter-Franklin's date of birth. And in addition to that, there was no evidence that the name that was used by the CJIS witness who conducted the search would in fact capture Mr. Lassiter-Franklin's name. And the reason for that is the testimony was that it was Dennis Franklin was the name that was used in the CJIS search. There was no testimony that using a partial name, a hyphenated name, an incomplete name would in fact yield accurate results for that CJIS search. And again, I would contrast that with Smith, where there was testimony regarding SoundX technology that was potentially able to deal with a misspelling of the name, but there was no testimony in this case about SoundX technology or that a search using not a complete name would yield accurate results. And I would also call the court's attention to Commonwealth versus Laquan Brown, which was just issued this past Friday from this court. That was an unpublished decision, but the facts are virtually identical to this case. Again, the CJIS witness testified to the date of birth that was used in in the search, and also the name that was used in the search, but the Commonwealth failed to produce any evidence actually that the defendant's date of birth was the name that was used in the search, or that the defendant's name.
Could you give me again the name of that case?
Yes, it's Laquan Brown, and I can give you, I don't have the official site because it was just issued on Friday, but it's 25P621.
And did you say Brown?
Laquan Brown,
Okay.
Laqwon. And the decision in that case dealt with the fact that the CJIS witness didn't testify as to the way the name was spelled. And essentially, I hesitate to read exactly, but I don't want to get anything wrong here. The court said the probative value of Dowd's testimony, that was the CJIS witness, depends in part on whether He spelled the defendant's name correctly in his search of the database, especially given the various ways the defendant's name could be spelled. There was no evidence of how the CJIS witness spelled the defendant's name when he conducted his search of the database, and they reversed the judgment, finding that there was insufficient evidence and set aside the verdicts.
Just to be clear, you actually raised two claims about the CJIS witness. The claim two is this one that you're talking about. There's a third claim about violating the Confrontation Clause. Smith, it goes against you on that one, right?
That's correct, and I would concede in terms of the hearsay and the Confrontation Clause that Smith is dispositive against us, but I do think that it's very much requires the court to find insufficient evidence on the issue of the licensure to carry, based on the lack of.
Was this case stayed or anything during appeal, or has your client already served his time?
I'm sorry, what was the first part of the question?
Was there any stay?
There was not a stay, no, and he has served the entirety of his sentence. I did, once Smith came down, I filed a motion to stay the appellate proceedings, but in terms of the sentence, no.
Okay.
Does the court have any questions for me in regard to the Smith decision or the Brown decision, or I can move on to the extrajudicial
I
statement?
think it looks like you can move along. I mean, it's sort of the reason I asked about the sentence, because I mean, whether we have to address, depending on what we do with that issue, whether we have to address the officers testifying about responding to a call, depends on if there's a retrial or not.
Sure. I would agree, and I think, again, I don't think the court actually has to reach the extrajudicial testimony issue, because I think that Smith is so clear, and then, again, with Laquan Brown, I think that derives directly from Smith and is, again, dispositive for this, even, well, persuasive. I understand that it's not precedential because it wasn't published, but the facts are even closer, and Smith is pretty darn close, but the facts in Brown are even closer.
In Smith, did they order vacating, an acquittal?
They found it. Yes, they found insufficient evidence.
But did they order no retrial because acquittal, double jeopardy? Yeah.
Right. Okay. Exactly. And I do just want to, I guess, before I head into the extrajudicial statements, I would just like to point to a couple of points that the Commonwealth brought up in their brief that I just want to address. The first is that the jury could potentially use its common sense to infer that the database would encompass the name Dennis Lassiter-Franklin, even though the search only entered Dennis Franklin. And as I noted in my reply, I think that's pure speculation. That will call for pure speculation where there wasn't any evidence of any testimony as to how the database functions. Databases function in many different ways. I know that when I put a name into mass courts, for example, unless it's precise, and I know that I have a client in there, I will get no results found, even though I know that my client has a case. Whereas maybe if you put something into Google, you would get a bigger cache. But I think in this case, I would just highlight the fact that I think that really requires an enormous leap on the part of the jury, and without that evidence, that the search would encompass a partial name, a hyphenated name, an incomplete name. There really is not sufficient evidence, and I think that that's the strongest argument, even over the date of birth for Mr. Lassiter-Franklin. Would the court care to hear my argument about the extrajudicial statements, if they don't have any questions about the?
Well, sure. Go ahead. I mean, I have a question about it. Why is it an abuse of discretion? Why is it outside the range of reasonable alternatives for the judge to say, okay, I'll let them testify why they're there, but I'm going to tell the jury that it wasn't in response to your client?
Sure. Well, the two arguments that the Commonwealth advanced were that they didn't want to put the police in the false situation of having to explain why they happened to be there. And then second, that they wanted to be able to explain why the officers used a show of force when they arrested Mr. Lassiter-Franklin. neither of those issues actually were present in the trial. So the officers were actually just on patrol and happened to see this person. So it wasn't a situation where they, and believed that he had tossed a firearm before they stopped him. And it wasn't a situation where they're just approaching some person who engages in no concerning or threatening behavior. They had seen this individual toss what they believed to be a firearm. And additionally, they were just on patrol. They were exactly, they weren't in a situation where they needed to explain why they were there. They testified specifically, we were on patrol in the area. So there was absolutely no reason whatsoever to need to explain either of those arguments that the Commonwealth put forward. So that's why I would say it was an abuse of discretion, because the basis for the need or the alleged need to put that in did not exist in this case.
So how is your client prejudiced by it?
Sure. The testimony was, I understand that there was a limiting instruction about this unrelated firearm investigation, but there were two officers, Officer Hassan and then I believe it's Sergeant Hoban. I think he was a detective at the time that he testified. And they really muddied the water. Sergeant Hoban testified that he was called to, I want to get this exactly right. He basically said that he was called to the area for a firearm investigation and then went to the scene of Mr. LASSITER-FRANKLIN's arrest after learning that the officers had a potential suspect. So even though the jury is getting this instruction from the judge that it's an unrelated firearm investigation and that there's, quote unquote, no evidence that Mr. LASSITER-FRANKLIN is related to it, then they're hearing, well, this officer that descended on the scene essentially was looking around in relation to this investigation, heard that there was a suspect or a potential suspect, and then arrived at the scene of Mr. LASSITER-FRANKLIN's arrest, which I think pretty clearly sends a message to the jury that this is, in fact, the person. And then, of course...
But the judge specifically told them every time that it wasn't.
I think it was... I understand that there was the limiting instruction. A limiting instruction does not necessarily mean that there isn't prejudice. I cited to Commonwealth versus Tanner in my brief. That is a case where there was prejudice found despite a limiting instruction being provided. And this is a case where it was all circumstantial evidence. These officers saw the defendant from about 30 to 45 feet away. It was dark. He's in an alley. He tossed something. They thought they knew what it was, but they weren't exactly sure. And then they find this firearm 2 fences over. There's no forensic evidence linking it to Mr. LASSITER-FRANKLIN. I think Commonwealth versus Parks, which I also cite to in my brief, is probably the best example of a situation where it's a circumstantial case against the defendant and then the additional piling on of connection between the criminal behavior and the defendant really tips the balance against the defendant in a prejudicial and unfair way. In Parks, it was that there was a driver who observed another driver indecently exposing himself while he passed him on the highway, and there was additional testimony that other officers or other people had reported making those same observations, but that wasn't accurate. And the additional corroboration of other people observing was found to be prejudicial for the defendant in that case. And I would just compare that to this. I think that additional corroboration, oh, there's a firearm investigation, they found a firearm, and right, so this must be the guy who tossed, the item itself that was tossed was a firearm. So I do think that that's what renders it prejudicial.
All right. I see. No, I think we get it. Unless you have anything else you want to add.
I will rest on that. Thank you for your time.
Thank you. Good morning, Attorney Morris.
Good morning. May it please the court, ADA Bryn Morris on behalf of the Commonwealth. This case asks the question whether a jury can conclude that a defendant illegally possesses a firearm based on the defendant's behavior with that firearm when approached by police. Unlike the cases of Quentin Smith and also the Brown case, here, upon seeing the police officers, the defendant engaged in a series of very suspicious behavior, ducking behind the car, tossing a firearm over 2 fences so hard that it hits a building and breaks on its way back down. In this case...
Isn't that consciousness of guilt evidence?
Yes, Your Honor.
Okay. Didn't Smith say that, wasn't there consciousness of guilt evidence in Smith too, and they said you can't convict based solely on consciousness of guilt evidence? Note 15?
What?
Footnote 15 of Smith?
I don't recall reading that in Smith, Your Honor, and I may be mistaken. Smith was under a very different posture where the defendant had a firearm in his back pocket, or I'm sorry, his pocket, whereas in this case, the firearm was tossed. But also, unlike in Smith, we actually do have some value from the CJIS evidence, even though it's not quite as compelling as other CJIS evidence might be. In Smith, the judge specifically did not take the CJIS evidence for its, did not take the defendant's date of birth as substantive evidence because it was hearsay, so the judge basically excluded that in the trial, whereas here, the evidence that was testified to was taken in as substantive evidence because quite frankly, at trial, licensure was not a contested issue in this case, whereas in Quentin Smith and also the Brown case, that was the contested issue at trial.
Well, the Commonwealth still has to prove beyond a reasonable doubt all the elements, though.
Yes, Your Honor. And we did that here by the combination of the defendant's behavior and also the CJIS evidence. The CJIS evidence kind of came in several different, shall we say, like, segments.
What about the fact that they don't use his right name?
So, 2 points on that, Your Honor. First,
there's like my wife has a hyphenated last name, and boy, if she gets it wrong or she uses one of them in TSA or whatever, she's not getting through. And Judge Hand's got her email has a different address than her name. That has because of our system. And so, the fact they use the evidence is that they did a search for Dennis Franklin, and leaving out the Lassiter part.
So, Your Honor, there was...
And then on the complaint it says Lassiter-Freeman, right? Like they knew his name.
Lassiter-Franklin, yes. Yes, they were aware of the name. The testimony about what name was run kind of comes in 2 different parts. Earlier on in the CJIS testimony, I believe the prosecutor asks a question that's something along the lines of, did you run or were you given the name Dennis Lassiter-Franklin, I believe? Something along those lines. I'm not quoting verbatim. And I believe that's on page 203 of the first volume of the transcript. And then later on, when the CJIS person is providing the name, the CJIS person says Dennis Franklin.
So you were asked to do it for Lassiter-Franklin. Yes, I did, but I did it for Dennis Franklin instead.
I don't think the testimony was quite that explicit.
No, it's not. It's not that explicit.
And where this wasn't a contested issue and both bits of testimony came in, I think the jurors can properly consider the CJIS evidence. In addition, on the date of birth issue, the CJIS person testified that this was the subject's date of birth, and I think that testimony can be taken as this is Dennis Lassiter-Franklin's date of birth. The difference between this case and the Smith case is that because in the Smith case, the judge didn't take substantively the testimony that the date of birth provided was Quentin Smith's date of birth. There was literally no evidence of date of birth, whereas here that comes in, albeit as hearsay, but it comes in under the sufficiency standard.
But there isn't testimony that this was the date of birth for Dennis Franklin. The testimony was this was what I searched.
It was the testimony was the subject's name and date of birth was Dennis Franklin, and then the date of birth.
The subject of the search.
What, Your Honor?
Subject of the search.
You could take that as the subject of the search, or you could take it as the defendant. I think it's appropriate to take it as the defendant, particularly in this case where lack of licensure was not a contested issue at trial at all. The defense at trial was that police didn't actually see a firearm thrown. Which brings me to the first issue in this case, whether the testimony was properly admitted, testimony about the unrelated firearms incident was properly admitted to explain police conduct. Here, when police arrived, the conduct was quite strong. I mean, they drew their firearms and they ordered the defendant to the ground. And that would seem quite a strong response to just seeing somebody toss a firearm or suggest they no longer have a firearm, but it becomes a much more appropriate response when jurors understand that the police were investigating an unrelated firearms incident. Regardless of whether that was properly admitted, though, here there was no prejudice to the defendant when it in fact bolstered the defendant's defense of police were wrong about seeing a gun. They just expected to see a gun, and that's why they saw one. So it was actually beneficial to the defendant's case rather than prejudicial. Additionally, the judge gave them a strong instruction that the defendant was not involved, or that there's no evidence before the jury that the defendant was involved in the unrelated firearms incident. If there are no further questions.
Seeing none? Okay.
Thank you.
Thank you. We got you done pretty quickly so you can get over to the other courthouse. All right, that case is submitted. And number 2 on our list this morning is Commonwealth versus Jean, 24P 1470.
Good morning, Your Honors. May it please the Court, my name is Emma Quinn Judge, and I represent the defendant, EPHRAIM. Jean or Jean is his Americanized preference for saying it. I also want to acknowledge my former colleague, Thomas Miller, who's here and worked substantially on this case. But this is a case where the trial was marked with error, many of which the Commonwealth now concedes were in fact errors. I want to start with the issue of the juror exclusion, because here you have the rare situation where a juror was excluded because he was asked twice about his national origin. But for his national origin, this juror would not have been excluded for cause.
For his national origin, the questions might not have been asked, but was the exclusion based on the nationality or based on an affinity bias concern? And does it matter?
I think the error is in asking the question, and the Commonwealth wants to shift you to the answer to the question. But here we have had a juror who's asked about this question of whether he has concerns about judging people. And he had assured the court he had no concerns about judging people. He'd assured the court nothing would interfere with his ability to be fair and impartial, to follow the law. He'd also assured the court emphatically 4 times that an old 1992 prosecution of him would not interfere with him being impartial. If he had not been Haitian, and if the defendant had not been Haitian, he never would have been asked the question, would you be more uncomfortable judging the defendant because he is Haitian? And that is clearly a question based on his national origin. You don't get that answer but for the fact that the defendant and the juror are Haitian. The Commonwealth concedes that it was a national origin question, but says because of the answer you have to strike him for cause. But I think, again, you have to go back to the question. There are other things on juror questionnaires. For example, prior history with the police. And you couldn't say to a juror, I see you have a prior history with the police and you're black. And this defendant is black and has a history with the police. You couldn't ask that question. It's clearly impermissible. And that's what we have here. We have a juror being asked a question about that is only asked, that would not have been asked but for his national origin. And I think looking...
So just to use your African-American hypothetical, so suppose a black juror says, I just have trouble judging people. I'm not, I feel uncomfortable judging people, and so you can't ask if the defendant's black and the juror's black. You can't say, would you be more uncomfortable judging a black person?
No, because that's a question specifically based on the identity of the defendant and the identity of the juror. You can explore, I think, the discomfort judging people, but you can do that only in a neutral way. You can't do that in a way that relies on the protected status. Looking at the formal analysis for this, right, the first question is, did the judge abuse his discretion in asking this question? And I think where the judge clearly misapprehended that a where were you born question was a national origin question, that's outside the range of reasonable alternatives. It's an error, it's an abuse of discretion. The next question then, of course.
Was there an objection to the question?
That's where I was about. That's exactly what I was about to get to. The next question is preservation. And when the judge said when the Commonwealth said, can you ask about his Haitian origin, and defense counsel objected and said that's approaching bats and sores territory. And obviously when you're invoking bats and sores, you're invoking Article 12 and you're invoking equal protection, because that's what those cases are about. And that, by the way, is the same argument we're making here. The Commonwealth is saying there was a different argument made at the time of the error versus now. We are in fact making the same argument here. And I would also note that one of the cases we cited, we don't discuss this in the briefs, but the Infante case from the Ninth Circuit notes that while you need to have a contemporaneous objection when you're talking about something like a Batson challenge, which this was not, because it ended up being a strike for cause, you don't have that same need for a contemporaneous record when the judge is striking for cause, because the judges are already then putting on the record the reasons for the strike. But where defense counsel said, this is bats and sores, he's invoking equal protection, he's invoking Article 12, which are the...
This is bats and sores.
This
I mean, it may be splitting hairs, but this is approaching bats and sores. Why doesn't that signal to the judge, like, this is okay, but next steps may not be, and I'll speak up later? Why is that sufficient to preserve the objection?
Well, because we didn't get to bats and sores, and I think he's flagging that the question is problematic, and we know that, you don't have to use magic words, you don't have to make a perfect objection. The problem with this question is that it denied the defendant a trial by a jury of his peers, and it denied him and the juror equal protection, their equal protection rights. And I think by invoking bats and sores, defense counsel made that clear. So this is I rarely get up and say this, but this is in the rare category of cases where you are talking about structural error. The SJC has said again and again and again that where you are talking about discrimination in jury selection, you are talking about structural error. The Commonwealth wants to compare this to the Williams case. And in the Williams case, you had a very different scenario. There, the juror came in. We don't know the juror's identity. The juror came in and said, based on my job, based on my work, I'm a teacher, I work with youth. I work with young African-American men, and I don't think they are treated fairly by the justice system. And in the Williams case, there's a discussion about, is that opinion automatically disqualifying? No. How do you deal with it in jury selection? But the court emphasized in Williams that the prospective juror was not struck due to being a member of a discrete group. And here the juror is struck for being a member of a discrete group because, but for the juror's identity and the defendant's identity, and I don't think it matters which it is. If you look at the Benoit or Benoit case, it talks about the fact that the defendant can raise the third-party equal protection rights of the juror. But for the identity of these men as Haitian Americans, this question would not have been asked, and this juror would not have been stricken. So I think it is a rare case, especially...
On the structural error piece, didn't the Commonwealth have a peremptory challenge left?
The Commonwealth did have a peremptory challenge left, and
that's how they got around it in Williams, right? Because the jury they would have been okay to remove that juror with the peremptory.
Right, but it wasn't structural error in Williams. In Williams, they said this is not structural error because the juror wasn't removed for their identity in a group. So I don't think there is any case that stands for the proposition that you could, for example, ask much more blatant, racist or national origin-based questions, and as long as the Commonwealth hangs on to one peremptory, no problem, right? I mean, that would completely gut the constitutional protection, and Williams doesn't stand for that because Williams is only about the juror coming in with this opinion. And there are also a host of other cases where jurors come in and offer opinions. And here even we had a juror who came in and said, I might have biases in favor of a complaining witness who is disabled. And the juror came in and offered that opinion and then was questioned about it. In this case, the juror even pushed back a little bit when the judge said, well, you're Haitian American, would that make it harder for you to judge people? And the juror initially refused to answer the question on that sort of national origin-based framework and said, I just don't want to judge people. And then the judge asked a second time, again, framing it in terms of national origin. So it's the question about national origin that is, I think, the clear problem here and the reason you have structural error, because you do have discrimination in the context of jury selection. Turning next to the Brady issue, this is a situation where everyone agrees that the Commonwealth should have disclosed this evidence and that it should have been disclosed earlier. So we are not in the territory of needing to sort of establish materiality or anything like that. The question is just whether the defendant was prejudiced by the delay or given a timely disclosure, whether he'd have been able to prepare and present the case in a manner that would have created.
Well, I mean, I don't know. Is it? Have we agreed that it's exculpatory? It is presented as inculpatory.
It was presented as inculpatory.
And the only, I mean, your claim of that it's exculpatory is that you, looking at it now, in hindsight, you see, well, it doesn't match up with the video. But isn't a much more logical explanation that the video is wrong?
There's no evidence that the video is wrong, and the Commonwealth relied on those timestamps. And I know
your client testifies that he was done with the victim at 3, and then he was on for another 2.5 hours. And the police respond around 4.
Right.
Under the video, he's finishing at 4.
The police respond around 4, and under the text messages, she says around 3:50 that the police might be getting involved. So
I think the text messages and the testimony and the medical records all line up. The only thing that doesn't line up is the video timestamps.
And if that's the case, I mean, the Commonwealth certainly could have said that the timestamps in the video are not accurate. But I think as far as the reliability of the timestamps, this is not. The only case the Commonwealth points to on this reliability issue is a new trial case where the defendant is offering an affidavit of a witness who is seen to be unreliable. Here what we have is evidence that was in the Commonwealth's custody and control, that there's no question, no one disputes that they should have turned it over.
Right. I mean, and your predecessor counsel got it on day 1. 24 hours later is when the victim and her sister testify. So he actually did have 24 hours. I mean, it's short. It's a very short series of text. He had it overnight to look at it. And
right.
Maybe, if he'd noticed something, he could have said, Your Honor, I moved to strike. Can I take that back? Can I actually use this, to my benefit?
Right, and I think, this is why we have these situations where the question is whether he had enough time to use it reasonably. And here, he got it, and within an hour, there had been a decision to exclude it, which is a reasonable remedy a lot of the time when you get new evidence on the first day of trial. At that point, I don't have any reason to think he's going back and going over those messages when he's getting ready for trial and getting ready to examine witnesses the next day.
Well, I mean, he knows that the next day that the victim's will be questioned about her text. She'd not be able to use the text, but she's going to be questioned about her first complaint. The first complaint witness is going to be questioned. Wouldn't it behoove him to have taken a look at this just in case it might come up?
It certainly might have, but I think what we can see on the face of the record that we have before us is that we have these texts that have timestamps that are inconsistent with the video that suggest that a complaint was being made or developed half an hour before the video shows the complaining witness in the treatment room. And it's certainly something that he could have used to undercut the credibility. And, we've argued that these are exculpatory because they suggest that she fabricated completely. But they're also exculpatory in the more sort of general sense that, we're used to as defense counsel, and that you can poke some holes. You can say, no, these were not private IMs. These were not individual messages back and forth. These were complaints made in the context of a group chat room called the, anti-straight group. And again, if defense counsel had seen that before, seconds before the argument on exclusion.
How does if the juror found out that it was a group chat in the anti-straight group, how would that would you say that would harm the victim's credibility?
I think it gives you a way to.
She's autistic, right? She has autism.
Right. I mean, I think it gives you a way to challenge the victim's credibility further, just to say this was not a one-on-one. I mean, the defense counsel theory was that she was sort of pressured. And there's a performative aspect to being in a group chat that there isn't necessarily to being in a one-on-one chat with your sister. And he could have certainly have exploited that advantage. And if he'd had these earlier, if he'd had these in a way that made the timestamps more accessible to him. Remember, this is a case also where, as you alluded to, the victim was autistic. She struggled on direct to testify. I mean, she was led consistently through her direct. She was showed a videotape in order to be led through her direct. Sometimes the videotape was replayed when she didn't answer the question right. The jury clearly didn't believe her in all respects because the jury acquitted on one of the charges, and this was a case that was entirely reliant on her testimony about what happened. So
was it the arm touching?
It was the arm touching.
Okay. Can you talk about the last issue?
Certainly. On the first complaint issue, I mean, there are multiple violations. The one that the Commonwealth concedes, of course, concedes as a preserved issue is the issue of the medical records, right? That is both a first complaint violation and it's a preserved first complaint violation. And it's very much...
I know that the Commonwealth concedes that, but in the motion in limine there, did counsel actually say that the hospital records were a first complaint issue?
He said it was a hearsay violation.
So no.
He said, I mean, I would argue that first complaint is a subset of hearsay, but he does say hearsay throughout. I mean, not a subset of hearsay. First complaint is a doctrine that is an exception to hearsay. So he does say that throughout. But I would just note that, in Cruz, this court looked at medical records on a substantial risk of miscarriage of justice standard, very similar medical records, very similar sort of he said, she said situation, and did say it reached that issue. In Ramsey, you had prejudicial error, and another case where there was a charge that the jury acquitted on, so again, having some questions about credibility. And here, the Commonwealth, not just on the medical records, but on the other pieces of the testimony, directly refers to it in their closing. I mean, they exhort the jury to look at these medical records and see how consistent she was. I mean, it's not just something that kind of incidentally comes in. It's something that the Commonwealth squarely talks about. The Commonwealth also makes a big deal out of the fact, and this is another subset of the first complaint violation, that the police reported to the scene and he was arrested right there. There's multiple instances of testimony that is only about the course of the investigation and the fact that he was arrested. This is not a case. The Commonwealth cites two cases to say that this would be okay. One is Dargan, which is a case where a defense counsel opened by saying, look at all these opportunities the victim had to complain to someone and she didn't do it. So it was obviously responsive to that. The second case the Commonwealth cites to say that there would be no error here, no prejudice here, is McCoy. And there you have a case where multiple witnesses were cross-examined about inconsistencies in the victim's testimony, and then inconsistencies in the victim's testimony were a centerpiece of the closing, which is not the situation we have here.
Okay. So I think we can leave it at that. I noticed Attorney Kern, we have a yellow light didn't go off that time. Is there any way you can fix that? We went straight from green to red. If you can. If not, Attorney Lynn, you've been here before. You might miss the yellow, so keep. Just an understatement if I've ever made it.
Good morning, Your Honors. May it please the Court, Paul Lynn for the Commonwealth. Starting, as my sister did, with the issue of the Haitian jury, there is no case that I know of that holds that a discussion with a juror, a potential juror, about racial background or bias alone is a structural error. In the case we both discussed in our briefs, the problem was not that the judge did not, that the judge asked the jury about her racial bias. The issue is that that was the only thing that they asked her about. It was simply that she felt that that young black men were getting a bad rap from the justice system. And the court said, no, that's not enough. You have to, because a lot of jurors will have that opinion, you have to determine whether they can still decide a case based on the evidence they hear at trial. And that's exactly what happened here. The judge asked the juror, you mentioned that you don't like to judge people. Would it matter that you're Haitian and this defendant is Haitian? And he answered, yes, it would. And at that point, that is a valid grounds for...
And so, I mean, so it'd be okay, like the hypothetical I asked before, if you substituted black for Haitian, that would be okay too?
Yes, it's okay. If the juror says, no, I cannot consider the evidence fairly under these circumstances, that is a valid ground for removal from the jury. Turning to the Brady issues, there's an issue as to whether this is a Brady issue at all. The prosecutor, who was a substitute prosecutor, took over for a previous prosecutor, did not know, couldn't swear based on firsthand knowledge whether these had been turned over, but they were in a computer file, she said in court. They were in a computer file that said photos turned over.
Doesn't the Commonwealth have the obligation to establish that that actually happened?
Yes, but I mean, we brought in that evidence. We brought in the evidence that that was this folder. The defense counsel had other evidence, the surveillance videos and the photographs taken by the police, but simply claimed that he did not have this one. And the judge said, well, I'm going to exclude these text messages or posts. As you have noted, Your Honors, this is a case in which there was clearly an error in one of the two videos, because you have the complainant saying, by the way, I'm at McDonald's on the Discord messages. That was clearly after, everyone agrees that was after the alleged assault and after the dental treatment.
Unless the whole going to McDonald's is also a lie.
This is true, but it's common knowledge that you can't use a phone while you're lying back and having a dental treatment. There's clearly an error here. There's clearly a mistake. And so the question is whether or not that fact alone requires reversal of the conviction here. And the answer is no. That if this had been brought up, the Commonwealth could have presented evidence. It was actually, the defendant did file a motion for new trial in this case, and in that motion for new trial didn't present any evidence that...
The motion for new trial didn't address this issue.
No, it did not.
It was just kind of a very broad,
Excuse me.
broad, vague motion.
Yes.
I mean, would this be a proper subject, a more proper subject for a motion for new trial?
Yes, absolutely, because then we would learn more about when this evidence was excluded. We could learn more about the calibration or lack thereof of the surveillance video, and certainly how the timestamps on the Discord messages are calculated. There's no evidence of any sort of that in this case. And so you simply have an issue that was not raised at trial and was not inherently prejudicial to the defendant.
Does the fact that the Commonwealth had a peremptory challenge left, would that make it, even if there was error, make it harmless? Or as Attorney Quinn Judge says, you can't just hold back a peremptory in case, as like your get out of jail free card?
No, I don't think you can just hold on to a peremptory challenge unless that's central to the...
So it wouldn't be, we couldn't say it's harmless on that basis?
No,
okay.
no. Turning to the first complaint issue, again, I do rely on Dargan and McCoy. These are cases that say that where there is an error, there's additional fresh complaint evidence. I mean, it's not first complaint evidence, it was fresh complaint evidence. Where there's additional evidence, that can be harmless error where the evidence is consistent with the defense. And here the defense is that she made up the story and because she was under pressure from her sister, and then once she started talking to the police and her doctors, it got out of control, that she couldn't control the story anymore, and that's why she continued to mention this alleged assault.
Although, I mean, she manages to say the same story time and time again. And I mean, after a while, doesn't that make it, wouldn't the jury think that, well, she keeps getting the details the same? Doesn't that mean they must be true?
Well, it's not entirely the same. She doesn't mention the rubbing of his genitals on her arm in all of her statements. She does in the Discord messages, but it's not entirely consistent. But yes, I mean, there's clearly, that's why we don't have fresh complaint anymore. It's why we have only first complaint. But I think in this case, where everything is centered on what happened at the specific time, the entirety of these statements are made in the course of an afternoon. They're not additional testimony coming in, tons of witnesses coming in and saying, oh yes, she told me this, and another witness told me this. It's just all a handful of witnesses who are told the same thing in the same time frame. And that's the reason the Commonwealth argues under Dargan and McCoy that this is harmless error.
Did you hear my question to Attorney Quinn Judge about, did they actually, you actually give them the benefit of having preserved the hospital records one, but did they actually?
The trial counsel certainly objected to the medical records. Yes, I note now that he did not explicitly mention fresh complaint, but he did mention hearsay. I do give the counsel the benefit of the doubt in that's suffice to alert the judge to the problem. If there are no further questions, the Commonwealth will otherwise rest on its brief.
Thank you both. Really well argued. Always appreciate your candor, Attorney Lynn. And case is taken under advisement. Third case today is 24P493, Commonwealth versus a juvenile. You guys good going for one more case after this? You good for one more after this? Let's see. Depends on how.
Good morning, Your Honors. May it please the Court, I am Joseph Schneiderman. With me is Ida Kondreva, the youth's trial counsel. We represent the youth. The youth refers to himself by his initials, so we will be calling him the youth today to protect his privacy. The Commonwealth always bears the burden to justify a pat frisk with specific and articulable facts that a person is armed and dangerous. The Commonwealth wants to validate this pat frisk because my client had a prior gun arrest, happened to be in a bad neighborhood with alleged gang members. These labels without substance ultimately add up to zeros and not the specific and articulable facts that Article 14 demands for multiple reasons. First, we don't have evidence on this record of secretive movements, a bulge, weighted pockets, waistband adjustments, or anything else suggesting that my client had a gun. Crowder reaffirms that officers cannot employ labels like blading or otherwise without explaining them. Granted, Officers Fulham and Sanchez do talk about what they saw, but what they saw was ultimately my client looking away from them. That's in the body cam, particularly at Officer Fulham's body cam at 2 minutes, 29 seconds, at page 7 of Suppression Volume 2, and indeed at Trooper Aldridge's body cam from 1 minute, 30 seconds to 3 minutes and 40 seconds. My client is looking away. At a couple of points during that, he can be seen touching the window of the Honda that he's standing next to, but he's not doing anything that's secret, and as the Supreme Judicial Court reaffirmed in Torres-Pagan, furtive really means secret. You have to be doing something to conceal yourself.
Counsel, can I ask this? It seems to me that one of the things that weighed in the analysis heavily, not surprisingly, is the testimony about the prior firearms arrest. Mm-hmm. And at trial, if I'm recalling correctly, trial counsel raised an objection, but not a written motion in limine. Is that right? So
that's right.
Okay. And sought to exclude Officer Sanchez's testimony,
That's correct.
But am I right that the request was to limit Officer Sanchez's testimony discreetly? That was what the issue was that was raised to the judge.
That's correct, Your Honor, yes. My trial counsel sought to limit Officer Sanchez's testimony based on a prior encounter.
Okay. Officer Sanchez was being called, according to trial counsel's view, and apparently so, to testify that he was aware of this prior firearms arrest because he'd been involved or present for it. Is that right? But then Officer, is it Fulham?
Yes.
Also testified at trial about his awareness of the firearm. Is that right?
I believe that's correct. I don't remember the page, but I remember that, yes, Your Honor.
There was no objection to that, correct?
There wasn't an objection to Officer Fulham.
Okay, so even if the decision to permit Officer Sanchez to testify was error, how was it prejudicial if there was then unobjected to testimony that came in through another witness on that same issue?
Your Honor, if there was, prejudice would still flow because Officer Fulham was the fulcrum of the Commonwealth's case. If Officer Sanchez's testimony should not have come in, Officer Fulham's would have come in. But I think actually in any event, the court does not need to reach whether or not the exclusionary rule goes this far because all we have is a single encounter that's 10 months old. Officer Sanchez testifies that he previously arrested my client. That's at Suppression 3, page 68, for a gun charge. He saw my client again. He arrested him in August of 2021. I want to be clear about that. He saw my client again 2 weeks before the encounter on June 7th, where my client indicates that he, quote, beat the case. So I think, to Your Honor's question, there's not necessarily a need to reach the exclusionary rule. If the court chooses to reach that issue, though, it is still prejudicial because all of this really turned on Officer Fulham's testimony. And if Officer Fulham's testimony went to that, or even if there wasn't an objection to that, we would be faced with purely with his credibility. So,
So the beat the case testimony, the suppression of that gun occurred before this incident completely.
That's correct, Your Honor. As far as we know from this record, yes. I know the Commonwealth makes much of that, but yes, as far as we can tell on this record, the beat the charge predates this encounter on June 21st.
We don't know, though, from this record, do we, why? What the basis of the suppression was?
We don't know, Your Honor. I concede that, actually, in my reply brief, that we don't know the basis for it. I think if in the future, the better practice would have been to ask the motion judge to take judicial notice of the prior decision, or indeed, if it's available, attach a copy of it to the motion to suppress and flesh it out in writing, as I think Your Honor was driving at. But again, I think there's no need to reach that issue because the prior arrest just does not have the substance that this court is looking for. It's a single encounter, and assuming danger based on one prior gun arrest without more collides with Cordero, or worse, assumes that someone who is a young person is dangerous, and we do not punish status. Your Honor.
Can we break that down a little? And you're using the word dangerous, which, so I mean, there's two, for a pat frisk, there's got to be armed and dangerous. So would the evidence go to armed, perhaps, but not to dangerous?
That's exactly my point, Your Honor, which is it might show armed, but it would not show dangerous. And indeed, I think actually there may even be doubt about armed because we don't know what the charge was. It could have been improper storage. It could have been carrying. I mean, we don't know much. The record is not developed, and that goes to my big picture point, which is the Commonwealth cannot rely on labels without facts, particularly where the Commonwealth bears the burden of proof. A pat frisk, like any other warrantless encounter, the Commonwealth bears the burden to prove that it's lawful. But I think more to Your Honor's question about breaking down armed and dangerous, we don't know much details, and assuming dangerous because of my client's age would punish him for something that is outside of his control, and the SJC has rejected that. Some free-floating notion of danger arises from age in the Keniston case, or worse, as I cited in the brief, it echoes the hardened dissent from California talking about super predators. We cannot rely on innuendos to assume that someone is carrying a gun. That actually takes me to one of my points, which is the evidence of a high crime area and of gang activity stems from innuendo. Officer Fulham talks about two gun arrests at Villa Victoria spread over a long time. That's at volume 2, pages 8 and 9, and again at volume 3, pages 6 and 7. One of those encounters is a month ago. The other one is 2 years ago. Officer Fulham makes an arrest on a quarter of a mile away at Washington and East Newton Streets. That's at volume 3, page 6. And we don't have a concern that gun activity is actually occurring on June 21st. What we do have is that officers are on a directed patrol for quality of life issues, but they don't explain a link between quality of life and a gun charge. If Officer Fulham had testified, Your Honor.
I'm sorry to interrupt you, but wasn't the testimony that the police were in the area due to an uprising in gang-related activity and quality of life issues, and that the police had been requested by community groups to be present in exactly that area?
That's absolutely correct, Your Honor. My point was that we don't have more than that to say what the gangs are doing. All we have really is we have three gangs, excuse me. The Lennox Street Gang, the Heath Street Gang, and the Villa Victoria Pirates. The officers don't say Lennox Street and Heath Street are rivals. They're warring with each other. We don't say that Villa Victoria is passing guns. All we have is the labels that we have three gangs in this neighborhood in the South End, but there's nothing further to... Your Honor, I'm sorry.
No, that's fine. I'm looking again at the transcript, the first transcript, I think, first trial transcript that said, and it's one, I take your point, but there's one section that said there was a neighborhood association that reached out complaining of gang activity, drug activity, and firearm activity in the area of Shawmut Ave, which is an area frequently occupied by a particular gang. Is that not some evidence to suggest that there is more, that it supports the high crime characterization that was given to the neighborhood?
Your Honor, high crime, even if that's correct, in other words, that we accept that Shawmut is within the orbit of Villa Victoria, we don't have enough beyond that. We only have Officer Fulham testifying to 2 arrests that are very spaced out, and as this court has reaffirmed actually 3 different times, in DM, Sertle, and Powell, we need temporal and spatial proximity. So although there's concern about that, we don't know more than that. So if the Commonwealth wants to rely on this label of a high crime area, they have to say, okay, we are saying that the orbit, and orbit could be, I suppose, a half mile or whatever, it's up to the Commonwealth to prove this, but the Commonwealth has to say that at Villa Victoria or within a half mile of Villa Victoria or whatever, that's our high crime area, this is our evidence. Here the record is all over the place. I appreciate Your Honor's point that we had some neighborhood associations discussing that, but we also have evidence of an arrest far away on a main drag. There's discussion of it on Columbia Road. I don't see how that's distinguishable actually from DM, where this court recognized that Columbia Road is a main drag between Roxbury and Dorchester. So I think to Your Honor's question, the evidence of high crime area is meandering, and although there is discussion of that, there's not more discussion of what it actually entails. In other words, are the gangs there? Are they threatening people with guns? Are they flashing guns? Are they flashing signs? We just don't know anything beyond that, and whereas here the Commonwealth bears the burden of proof, it becomes compelling, and it's not enough for the motion judge to translate that into a finding.
Can I ask you a practical question?
Certainly.
So I think you concede that the police did have reasonable suspicion to stop and talk to the group that had congregated. So there's this group of young men sitting around drinking, smoking. It looks like vaping, and the neighbors are complaining. What are the police supposed to do in a situation like that? I mean, if we tell them you can't search the members of that group for guns, what are they supposed to do?
Your Honor, they are supposed to go as far as they did when we saw them initially on the video. The officers absolutely could have a chat with them. I don't quarrel with that. The sight of the bottle on top of the car created reasonable suspicion of drinking in public or of underage drinking. What we don't have, though, is a link between the sight of alcohol and armed and dangerous. If the officers testified, in my training and experience, I've been in Roxbury for 5 years. I have made numerous arrests for drinking, and I've found a gun, and I know that alcohol and firearms are a dangerous combination. We wouldn't be here. So the officers absolutely can ask where they went wrong is during the pendency of the encounter where they surrounded my client, they were walking around him, and for lack of a better word, Your Honor, rousting him. My client was standing there passively smoking. If the officers had come in and testified to that, we wouldn't be here.
And there was no testimony or finding that they felt that they were in danger.
There was no, I recall no testimony of that either, Your Honor. To the contrary, we actually have evidence that tilts the other way, which is Officer Fulham pat frisks Mr. SLB. That's again at the body cam at 229 and again at volume 2, page 7. Indeed, he pat frisks Mr. SLB in his groin and finds nothing. So I think any finding is unreasonable on this record, and indeed the only knowledge actually that my client, Your Honor.
If you were representing that person, would you say there was no reasonable suspicion to pat frisk him as well?
I would. There was no suspicion to search Mr. SLB, and officers cannot be allowed to exhaust every investigative avenue. And indeed, where a search turns up nothing, this court and the SJC have reaffirmed that it's impermissible. The only evidence we have actually of gang members or of gang activity is filming the music video. We don't know what that music video was about, but the SJC has recognized a grievous risk of punishing expression based on prejudicial assumptions about that.
I'm not sure where that came in the decision-making. I understand where the testimony came in, but how did the rap video enter into the reasonable suspicion calculation as far as you see it?
Your Honor, I believe it goes to the judge's findings at my brief 110.
I see it in your brief, I just don't see it in the judge's.
I'm referring to the judge's findings, Your Honor. The back of my brief is page 110, which is also the May 1st volume at page 6. I don't know why the juvenile court brought up so many transcripts. But there's no mention of the video, but I think it goes to the calculus of gang activity here. And I think you cannot translate protected expression, indeed culturally sensitive protective expression, into a finding of suspicion that one is armed and dangerous without substance. I see the yellow light works again. Unless Your Honors have any more questions, I would just say that validating this frisk as adding up multiple zeros into a dragnet technique that this court recognized long ago violates Article 14, and I thank the court for your time.
Okay, thank you.
Thank you, Your
We'll hear
Honors.
from the Commonwealth.
Good morning. May it please the court. Ian McLean on behalf of the Commonwealth. Your Honors, the totality of the facts here added up to reasonable suspicion that the juvenile was armed and dangerous, and that justified the frisk. There were a series of factors in the totality of the facts that led to that conclusion. I would start with the fact that the officers were outnumbered by this group. The motion judge found that the group consisted of up to 8 people, so they were outnumbered to begin with.
How many officers were there?
Initially 2, but ultimately there were 6 between 2 cars that arrived on the scene ultimately.
And when the pat frisk of the juvenile occurred, were there 6 present at that point?
The record's not perfectly clear, Your Honor, so I can't say exactly how many were there at that exact
But more
moment.
than 2 at that point?
Correct, Your Honor. But beyond just the fact that they were outnumbered, this did occur in a high crime area, which under Jones-Pennell is a factual finding. So the motion judge here found it to be a high crime area, he just didn't use those magical words. If you look at page 6 of May 1st, when he orally announced his ruling, he was saying this is a high crime area. And he was saying it was a high crime area based on basically the 3 things that the community group had reached out to the law enforcement officers about. Those 3 things being gun activity, drug activity, and firearms activity in the area. So the motion judge did find this to be a high crime area, and I think on this record, you can't say that's a clearly erroneous factual finding. This is basically, it's very, very similar to the basis of finding high crime area in Jones-Pennell, which was arrests in the area, crime on the street in question, and targeted patrol due to increased criminal activity. That's basically what we're looking at here. So we have outnumbered officers in a high crime area approaching a group of individuals, 7 of which they recognized to be gang members. 7 of the 8 they recognized as known gang members. 2 of those members they recognized as having prior firearm arrests. So that's the situation they were presented with. On top of that, the juvenile...
The other one, the guy they frisked first?
No, Your Honor. My understanding is that it was a different member of the group was the first frisk. The 2 people that they recognized as having prior firearms were not the 2 people that they had recognized, is my understanding.
I mean, I know that juvenile's not in front of us, but I mean, so they kind of just randomly.
The record's not
Frisk him?
fully developed as to why they chose to frisk that individual, and not really pertinent, other than the fact that they did and they didn't discover anything. So they recognized this juvenile as having a prior firearm arrest. And the next thing about this juvenile in particular was the atypical behavior. And I'd point you to Sweeting Bailey. It's a similar sort of situation as in Sweeting Bailey. In previous interactions with this juvenile, he'd been loud, aggressive, confrontational. Here he was quiet, withdrawn, sullen, head down, hoodie up, and he was holding a fanny pack, bag, shoulder bag, which they recognized based on their training and experience as something used to secret firearms. This particular bag was one that they had seen on a different member of the group, who I just made up the initials for of MN in the group, and he was the other person that they recognized as having a prior firearm conviction.
Did the judge put that together in his findings? That bag was connected with the prior firearms?
So he did not. What the judge said about is a Gucci shoulder bag. What the judge said about that is, I am not considering it because I find there's reasonable suspicion before I even consider the Gucci bag, shoulder bag. However, the motion judge did expressly credit both of the officers who testified, and the officers testified about that fact, that they recognized the bag, to be normally seen on the person of MN, the other person in the group that had a prior firearm arrest as well. So we have a juvenile who's holding a bag that they don't ever see him with, that they see a different person with a gun case holding usually, and the juvenile acting atypically. Instead of being loud, confrontational, rude, he's quiet, sullen, withdrawn, keeping his hoodie up and shielding the part of his body from officers' view. When you add all of those things up, we're basically looking at a Sweeting Bailey type case here.
What do we do with the issue about the challenge to Sanchez, not to Fulham, but relating to the evidence about Sanchez's involvement in the prior firearms arrest involving this juvenile?
Well, honestly, Your Honor, I think it's completely irrelevant. The fact is, what we're talking about here is, was the officer's suspicion that this juvenile was armed and dangerous reasonable? The fact that they know that both this juvenile and a different member of the group have prior firearm arrests, meaning they had firearms on their person, is what counts here, not the ultimate disposition of either of those two arrests. And I'd point you to De Silva for that. In De Silva, 2006 case from this court, ultimately the prior arrest was dismissed in that case as well, but that was irrelevant, because the point here is what was in the officer's head at the time of this interaction. At the time of this interaction, they were aware this juvenile had a relatively recent prior firearm case. Another in the group had a recent firearm case. They were in an area on a targeted patrol due to an increase in gun activity. They were interacting with a series of gang members, and the juvenile was acting atypical from how he normally does and shielding part of his body away from their view. You add those things up, and we're well over the reasonable suspicion to justify a frisk. Reasonable suspicion meaning just specific and articulable facts. We have a whole series of specific and articulable facts here that justify the officers frisking this.
So you could distinguish between finding that the juvenile is armed as opposed to being dangerous? Where's the dangerous?
Well, Your Honor, I think the presence of a firearm at any time is dangerous.
That's telling me that when this SJC and Torres Pagan says armed and dangerous, they're being redundant. All you have to show is armed.
Basically, yes. But even if you wanted to consider they were separate determinations that had to be made separately, even though none of the cases ever talk about a distinction between the two, but even if you wanted to consider them separate, here, so we have ample unarmed based on his history and his behaviors. Now we have a juvenile and a group of juveniles that are gang members, and we have open alcohol being consumed at the time. So we have, I'd point you to the SJC's cases in Madison Perez recognizing juvenile brains and their lack of impulse control and their frequent inability to prevent themselves from being involved in violent criminal activity. So we have a group of known gang members, two of which have prior firearms, open alcohol in the area, and they outnumber the officers.
So, are we allowed to, of course, I watched the video, right? We watched the video, and there's a group of kids congregating. It's broad daylight. They're smoking and drinking. They shouldn't be doing that. But they don't look particularly scary or dangerous, and the officers don't look particularly scared. They're circling around. They're talking to them. There's these. And you said the fact that the juvenile is subdued is evidence that he's dangerous. Isn't it just if he's if he's making a lot of noise, isn't that evidence he's dangerous too? Or am I not allowed to look at the video and make that conclusion?
Well, of course, you can look at the video and you can review the motion judge's factual findings as a result, but the motion judge's factual findings here are not predicated solely on the video. They're an amalgamation of the testimony with the video. So I think that means the factual findings are due deference. As to the juvenile being sullen or withdrawn or whatever terminology we want to use for it, the reason that's significant here is because it is atypical from his normal behavior, which was loud, aggressive, confrontational, hostile to police. Now here...
So, I mean, but if he had been loud and confrontational, would that be evidence that he's dangerous?
Not necessarily, if it's consistent with his behavior. If he's just rude to
None of these
officers-
kids are, if all these kids were being loud and confrontational, I would have felt a lot better about the police frisking them instead of being quiet and they're all kind of like huddling together.
Well, we're significantly changing the facts of what happened here. And the reason that his behavior is pertinent in this calculation is because it was atypical. Normally, this juvenile is hostile, aggressive, rude to officers. Now this time, he is sullen, withdrawn, shielding part of his body, and holding a fanny pack that in their training and experience is a bag frequently used to secret firearms. And he has a prior firearm arrest. Also, the person who they normally see holding that fanny pack has a prior firearm arrest and is not holding it now. So if you put those things together, they're entitled to draw reasonable inferences relying on their training and experience. You have a juvenile who is acting abnormally and holding a thing that is frequently used to secret a gun. So that is why it adds into the reasonable suspicion that this juvenile is both armed and dangerous at this time. Again, it's a totality of the circumstances. It's not one individual event or fact here. It's a series of events or facts together that you and I, looking at on body-worn camera, might think this is a completely innocuous situation. However, these are experienced officers that interact with these juveniles and gang members on a regular basis, and we have to trust their judgment. Also, they're entitled to take reasonable steps to ensure their safety, and I point you to Carrera for that. They don't have to assume the risk that they're about to get shot. So the question here is whether their action, their suspicion this juvenile was armed and dangerous is reasonable, and based on the totality of the facts here, it was absolutely reasonable. Reasonable suspicion being just specific and articulable facts. Here there are a plethora of facts. The motion judge got this correct. If there are no further questions.
Okay, seeing none. Thank you both. Again, well argued. And we'll take that. Well, that case will be submitted. I think we're going to hear one more before the break, assuming that the counsel are here for court for case number 4, which is 24P 742. 3 for 3. Excellent. Yes, so the next case is 24P 742 DCF versus father. Yeah. That was more for the record. And Chief Smith, we will take a break after this case. Okay.
Thank you. May it please the court. Good morning. Roberta Driscoll-Weiss here today on behalf of the appellant father. I have 2 requests of the panel today. First, I'm asking that the panel vacate the termination of my client's parental rights and remand the matter back to the trial court because he was denied effective assistance of counsel. More than that, though, I'm also asking that this panel issue a written decision concluding or applying the CPCS performance standards to the determination of whether or not appointed counsel in a child welfare case has been ineffective. I will start by saying that my goal here today is not to call out an attorney for making a...
Of course, just to clarify your two asks there is, should be, if we were to remand, would it be for a hearing on the ineffective assistance claim? Or you want us to, or on the basis of the trial record, you want us to say there's ineffective assistance?
Oh, he's starting with a hard question. Well,
I should save the one till the end, but.
Well, procedurally, I think this court can conclude that trial counsel was ineffective. Alternatively, remanding on that issue would be satisfactory, although I think the evidence is pretty clear that trial counsel's conduct fell below that of an ordinary fallible attorney and that father was prejudiced as a result. The reason that I bring up the CPCS performance standards is I think it's important to point out that these cases are so vastly different from criminal cases, and that's where a lot of the ineffective assistance of counsel, the body of law governing ineffective assistance of counsel, comes from the criminal case. In a criminal case, by and large, and of course there are always exceptions, but by and large, by the time counsel is appointed, the event has occurred, and the issue is guilt or innocence, mitigating factors, et cetera. But an individual's conduct and what that, the actions that an attorney takes on behalf of their client between that event and the time of trial are vastly different than they are in a care and protection case.
But in this case, the counsel was only appointed 90 days before trial, and the case had been pending, and your client had action or inaction for years, correct?
Well, I think factually that's accurate. Whether or not my client was inactive during that case, I think it remains to be seen. But trial counsel had options available to her. She was appointed in March. Trial was scheduled for July. At any point between March and July, she could have sought a stay or a continuance of that trial because she needed more time to prepare. But what in fact happened was counsel was appointed in March. She didn't start working on the case until 2 weeks before trial. She didn't communicate with father until 2 weeks before trial. She didn't request the DCF file until 6 days before trial.
How many?
6. 6 days before trial.
Where does the issue of responsibility by your client come in, by father, to, like, what did he do between March and June to get in touch with her, or to find out where his attorney was, or to provide her with information? Like, where's his personal responsibility?
I'm not saying that the father had no responsibility here, but
Well, what did he do?
Well, first of all, I think the record isn't clear as to whether he was informed as to who the new attorney was. When counsel was allowed to withdraw in March, or in February rather, excuse me, the new attorney wasn't appointed on that day. That's not if the court is interested, I can tell you that at the Boston Juvenile Court, there's a list of attorneys, and the judge will then go through that list and appoint new counsel, and that did not happen in session in this case. So while father maybe should have called the court to ask who his new attorney was, the CPCS performance standards place an affirmative obligation.
Well, you say in your brief, trial counsel reported sending father a letter on April 3rd. Is that you don't say, you say reported, so you're doubting that actually happened?
I have no evidence that actually happened, Your Honor. I requested trial counsel's file. That letter is not included in it, and I believe that's also in the brief. That letter was never provided to me. Father's affidavit indicates that he did not receive it. So while trial counsel attests that she sent it, she didn't keep a copy, didn't provide a copy to me. I cannot affirmatively support that statement by her because that letter was not part of the file that she insisted was her entire case file that she provided to me. But going back to the performance standards, to answer your question, Justice Allen, the CPCS places an affirmative obligation on counsel when they're appointed, and it says that counsel shall, and that word is used over and over and over again in the performance standards. It's very rarely should. It's never might. It's almost always shall. Counsel shall diligently and zealously protect and advance the client's interests, rights, and goals in the proceedings. And one of those things that counsel is obligated to do is to decline the appointment if they're too busy and can't get started on it right away. If they don't decline the appointment, then counsel shall take appropriate steps to locate the client, and I'm quoting, immediately upon receipt of notice of the assignment. So while perhaps father could have contacted the clerk's office and made some effort to find out who his attorney was, the obligation was on her to contact him, and she failed to do that.
In the judge's findings, wasn't there some confusion or well, at least that the department didn't know where father actually was residing, that there was that he at some point he said he was in Georgia, at another point he said he was in New Hampshire working. That was actually one of his positions at trials, that he was going to send the child to Georgia, but he was going to live in New Hampshire. Wasn't clear to me that he was upfront with the court about where he was.
During the proceedings, father went to Georgia to care for his elderly father who subsequently passed away, and then he stayed in Georgia to settle his father's estate and then returned to the Northeast. Again, trial counsel does not say, I tried to reach my client and couldn't because I didn't know where he was. Trial counsel simply did not try to reach him.
Do we have an affidavit of trial counsel?
We do. Yes, Your Honor. It's it's in Record Appendix Volume 2. I believe it starts at page 311, if I'm not mistaken.
Counsel, can I ask a question just to be so I'm clear on what you're looking for as far as the standard goes? Are you asking that termination of parental rights cases have a standard other than Safarian, or are you arguing that the CPCS manual sets the baseline articulated in Safarian?
The latter, Your Honor. I think the Safarian standard that conduct fell below that of an ordinary fallible attorney, which was modified in Georgette to the second prong to that prejudice must be established. The point that I think I was getting at when I started was that these cases are so very different than criminal cases that it's very difficult to look at the end of the case and say, there was no prejudice here, because everything that a client does from the day the care and protection petition is filed until the trial concludes is fair game for trial. Whether it happened on the day the C&P was filed, whether it happened the day before trial, every action or inaction by a parent is relevant to the judge's determination of what's in the best interest of a child. So it goes beyond simply failing to file motions and failing to secure visits, neither of which occurred in this case necessarily, but it's the day-to-day work that private counsel does on behalf of their client all through the proceedings, and that's largely what the private counsel manual addresses and the standards that CPCS have set forth for us, what they're intended to address. So, for example, it's incumbent upon us to engage in discovery, and that's not just getting a copy of the DCF file, but it's getting a copy of all relevant records throughout the course of the proceedings. It's keeping the client informed and involved throughout the course of the proceedings. It's ensuring that the client has adequate services throughout the course of the proceedings. And
so the only I mean, I think it's an interesting point you make, how it's an evolving thing. But from what in your brief, the only thing that I think you say that counsel should have done that would have helped with the underlying case, no, I'm not talking about the proof at trial, it was try and get him more parenting time.
that was his primary concern, and that's why he had asked his previous attorney to withdraw. That was on the record, that he had asked his previous attorney to try to secure in-person visitation with his child. That attorney had failed to do so. He'd asked for a new attorney. This subsequent attorney at issue here today was appointed and then did nothing, took no steps to attempt to secure that visitation.
So the judge finds, so it's that he missed 21 of 22 scheduled video visits over a 2.5-year period leading up to June 2023.
Well, and
so I mean, back to Justice Allen's question about, what's your client's responsibility? Is there any evidence that he would have actually followed through with the visits, which he really hasn't done for most of the child's life?
Well, I think the record makes clear that there was a long-standing dissatisfaction on the part of my client with the idea that he was just having video visits. The judge even acknowledged that these video visits did not go well. This was a young child with attention issues that really couldn't sit still in front of a video camera. In terms of the number of visits that father missed, I think it's important to look at why he missed them. So what DCF did in this case is they said, you need to confirm the visit a day in advance. And if you don't confirm the visit a day in advance, the visit's not going to happen. So if the visit is scheduled for Tuesday and father doesn't call on Monday, The answer was not, okay, let's see if we can schedule something for next week. The answer was, your visit for this month is canceled. No makeup, no working with father to try to make these visits be what they're supposed to be. And I think if you look at Justice Leonard's
It's not
article,
essentially
which-
standard procedure with the department, though, that they manage hundreds of cases in each unit. And so they set up these procedures. Then it seems routine that you have to call the day before to say, yes, you are going to appear on the video the next day, so that they can then coordinate with the worker and the child and wherever the child is placed, and have all of the technology in place, and that is fair to the department. And further, wasn't it one of the court's findings that the father only had to appear for, it doesn't matter whether the visit went well or not, but he just had to appear for 3 virtual visits, and then he would get some in-person, and he could not do that. Wasn't that one of the findings?
So respectfully, and I do mean this respectfully, you're not wrong that that's the department's typical modus operandi in these cases. That doesn't make it right. Visitation between a parent and a child, if you, Justice Leonard from the California Supreme Court, I believe, he's been cited by this court, he's been cited by the Supreme Judicial Court, and has written extensively on the importance of parent-child visits in these types of cases. He has made very clear that visits can never be used as a reward or a punishment. So when father fails to confirm his visit on a Monday, why must he wait another month for a visit with his daughter? This is the department's regulations, self-promulgated regulations, require them to provide regular and frequent visitation. Once a week via video with a child who cannot sit still and cannot engage on the video, arguably is not reasonable. And the fact that it's their typical procedure doesn't give it any sort of endorsement of propriety. They should do better, and they don't. And in this case, whether that motion would have been successful or not, I don't know. If counsel had filed a motion for in-person visits, at least it would have, the entire discussion would have been before the judge, but father was denied that opportunity to have that heard by the judge and have the judge understand that what's happening here is that if he misses that window to confirm, he loses his right to visit for an entire month.
Well, the judge's findings make it clear she did understand that that was the case. Wouldn't you agree with that?
No, I don't think that that's true, because I think in sort of combining all of the visits that he missed together into one bucket, she doesn't distinguish between, well, these are the ones that maybe could have been rescheduled because the reason the visit was missed is because he confirmed late or failed to confirm or was out of town and didn't get the email, or for whatever the reason was. That under no circumstances in these cases is what father was being given here in terms of contact with his client. Under no circumstances was that adequate, and his ability to make that argument to the judge was foreclosed when his attorney failed to file the one motion that the one thing that he had asked over and over again was he wanted in-person visitation with his child. The manual doesn't say file a motion that you can win. It says seek your client's objectives, and she failed to do that.
Although the Safarian standard does say file a motion you can win. I mean, even if we agree with you that CPS standards are relevant on performance, in terms of prejudice, you can't show prejudice unless you can show motions that would have been capable of being won.
Well, and that's, I think, the other reason why I'm asking that part of the consideration not only be this affirmative showing of prejudice, which is very difficult in these cases, because if the failure was at the beginning of the trial, it's very difficult to show, a year later why that was, how a parent was prejudiced. It's more that the first prong, right? Being an ordinary fallible attorney, it doesn't mean that you can't make a mistake. We all make mistakes, and we can all look back with hindsight.
Pardon me for interrupting you. Your time is up. I do have a couple more questions that I want to get to. One of the things you fault counsel for is for not filing motions in limine. What motions in limine should she have filed?
I don't fault her for not filing them. She filed motions in limine.
Okay.
They were never ruled on. And she filed them on the last day of trial. And again, this is someone who was appointed months before trial. Even though trial was scheduled, she was appointed months before trial. She had adequate time to seek the DCF file, which she didn't seek until 6 days before trial. She didn't get the witness and exhibit list until 2 days before trial. And those motions in limine, quite honestly, should have been heard prior to trial so that evidence or information that was reasonably should have been excluded as inadmissible could have been excluded before it became part of the trial.
Give me an example, one example of that type of, what that would have been.
I'm sorry, I don't understand.
Give me one example of the evidence that should have been excluded.
Well, she makes a number of objections to statements in 51As and Bs that are not primary fact. And it's settled that a 51A...
Right. So did the judge make any mistakes in taking 51As as not being to set the table?
I don't know. In all honesty, I don't know.
The other question I want to ask you is, your client's parental rights were terminated as to two siblings of the subject child in 2018. Was there any appeal of that?
I don't know. I don't know. That was prior to my...
So would you agree that the department, that's one of the exceptions, and the department does not have to make reasonable efforts after that?
I would agree that that's true. I don't know that visitation is simply a matter of making reasonable efforts. I think visitation is so integrally important in these cases that it's more than just the department checking its box. But if I could just...
No, I think I agree with you. It couldn't possibly be that once you've had your parental rights terminated as to one, you're not entitled even to visits with the others.
And quite honestly, DCF didn't take the position that we're not giving him visits because he had his rights to other children terminated. They scheduled visits, although they were haphazard at best. If I could just conclude, just to finish answering the question, the issue is not so, for me today, is not only the prejudice issue, it's the first prong of being an ordinary fallible attorney. And it's one thing to make a mistake. It's another thing to accept a case and simply decline to do those things that you have agreed to do by virtue of being an appointed counsel that's certified by CPCS to take these cases. When we take these cases, it is our understanding, and we know that that manual tells us what our marching orders are, and to simply decide not to do them for, quite honestly, no good reason, goes beyond being fallible and becomes ineffective.
So, I mean, are you arguing that failure to follow the CPCS guidelines is per se prejudicial? It's like it's on the criminal side, there's a Cronin decision, US v. Cronic rather, that there's some failures that are automatic prejudice. You're saying there should be automatic prejudice?
I think it should be part of the calculation, and quite honestly...
Are you saying it should be automatic prejudice?
Yes.
Okay.
If the reason for not doing it was to simply not do it. I think what's missing here is any articulation by trial counsel that I didn't meet with father because of this reason, and I didn't file this motion because of this reason. We didn't even get to the issue of the witness, the domestic violence witness, which trial counsel decided would not be probative, except this was a woman who was willing to come to court and say, I lied. There was no domestic violence. I lied because he cheated on me, and I filed a false affidavit in support of that lie. I think that would have been quite probative, seeing as out of the 20 conclusions of law that the trial judge came to, 5 of them related to domestic violence. Would it have mattered if for this judge to hear from a live witness?
Okay, Attorney Riscois, we've gone off to stop you there.
Thank you, Your Honor.
Good morning. May it please the court. Matthew Price on behalf of the Department of Children and Families. The department is asking this court to affirm the decision of the lower court that terminated father's parental rights. It is also asking this court to affirm the decision of the single justice that denied the motion for father to take leave to file a motion for new trial in the lower court. Neither was an abuse of discretion. The basis for the denial of being able to return to the lower court, the single justice found the premise of the argument was also ineffective assistance, and the single justice found that the motion failed to demonstrate a sufficiently strong likelihood of success on the merits. That was not an abuse of discretion. Neither was the termination of father's parental rights.
Can I just ask you a procedural question on that? Normally, in ineffective assistance cases, we disfavor we disfavor claims that are brought for the first time on appeal, and we should actually encourage them to be filed in a motion for new trial. And the single justice foreclosed that avenue here. What are we supposed to do with that?
Well, it's before you to consider. It's the preferable method to bring it back to the lower court. But in this case, it had to go through the single justice because it was already docketed in this court. And presenting the ineffective assistance argument to the single justice, they found that it didn't have a sufficiently strong likelihood of success. To father's credit, he tried, and there's that. It's not that it was a step completely passed on.
I think it's sort of like in the ineffective assistance cases, there's sometimes a trial judge will decide it without an evidentiary hearing, and the issue to us becomes, was there a significant enough issue that it should go for an evidentiary hearing? I mean, I guess that's really the same thing that we have to ask here.
Correct, I think it is. And the standard for it is an abuse of discretion. And I don't think that that was met as far as being on appeal. There was overwhelming evidence of father's unfitness regarding the child. He had a long history of domestic violence. He was inconsistent in services in cooperating with the department. He had never parented the child. He had never, the lower court found that he hadn't parented his other children. He had 11 children, 6 of which were in the department's custody or had aged out of the department's custody or was in the another state's department's custody. He was not prepared to adequately deal with the special needs that the child has, and he was inconsistent for long periods of time on visitation. And his parenting plan, if given custody, was to remain in New England while he sent the child to Georgia. It was reasonable for the trial court to find that he was unfit. As far as his visitation, even if he had established a good record of visitation, which he did not, that alone does not necessarily make him a fit parent. It would be for the judge to weigh. In this case,
but I mean, so didn't counsel have an obligation to try and get him more visits so he could show the judge that he's changed? Because there's current unfitness and then the likelihood to remain unfit in the future. And what Attorney Driscoll-Weiss is saying on these, unlike a criminal case where it's done, this is an evolving situation, and that he could maybe make some progress that might change the trajectory.
Yeah, and he had, I would argue, he had plenty of opportunity to do that over the course of several years that this case existed. Not putting it all on the last 4 months where the 4th successor counsel was representing him. So initially, when he had visits and he was meeting the visits were increased. Conversely, when he started missing visits, the department cut back on the number of visits. And the reason why they did that was not to reward or punish him, but for what was seen as being the best interest of the child, where she kept getting, it wasn't good for a 6-year-old with special needs to be getting stood up by a parent on these visits.
But then doesn't that, in a way, play into the father's argument, where if there's a spiral that happens, the father does poorly, I'm not commenting on the reasonableness or unreasonableness of it, but he has diminished visitation as a result of his failure to satisfy the department's obligations regarding visitation, and he becomes more frustrated. There's less incentive, arguably, for him to comply. Isn't that where opposing counsel is saying that the Hail Mary that maybe the final attorney could have tried to execute here would be to stop that cycle and say, look, I get what's happening here, but can you just give this father the opportunity to prove himself, right before trial? Can we just see if he can pull out of this in a way that might change the calculus at trial? And isn't that a fair argument?
I think it's a fair argument. I think that what happened here was that trial counsel did reach out to the department to ask that he have more visits. Ultimately, it's incumbent on him to follow through and do that, and he didn't do that at the largest period of time for 2 years, where there were 22 visits scheduled. He didn't appear for 16. He confirmed 5, but then didn't show, and he attended 1. Even if visits had gone well, the father hasn't established where the prejudice was in this case, considering the overwhelming evidence. Visits only encapsulate one aspect of what the trial judge is considering. And as far as prejudice goes, on the 5 claims of error that is raised as far as being ineffective, they don't establish that the overall performance of trial counsel resulted in a prejudice to him, or a better performance would have established that he was fit. He was not fit.
Was trial counsel's proposal at trial just for, what was trial counsel's proposal, father's counsel's proposal at the end of trial? Do you know what they proposed with respect to this child? Like, was it immediately to return the child to him and he was going to take the child to Georgia? Or was it to start having parents? Like, what was the remedy? Because I'm struck by the small amount of time between her appointment and trial, and it seemed like a short amount of time to bring a motion. And so I'm wondering if it was perhaps part of a proposed decree or a proposed, plan of reunification.
My understanding from the judge's findings were that he was seeking to establish his fitness, and his parenting plan, which the judge was aware of, was to send the child to Georgia while he stayed in New Hampshire. The points of...
So was trial counsel arguing my client is fit?
Yes, I believe she was. Yeah. The CPCS guidelines are guidelines, as are the rules of professional conduct. Safarian and through Stephen, child welfare cases have adopted the Safarian standard, establishes the standard. The CPCS standards do not. The intention of Safarian is to look at the overall performance of an attorney, not a particular action or non-action. And for those reasons, it's not intended to be a checklist of what they did right or wrong. For those reasons, we would ask that you affirm the lower court and that prejudice has not been established here. And if there's not further questions.
We'll hear from counsel for the child. Thank you.
Thank you.
Good morning, Your Honors. Colleen Duran on behalf of the appellee child. May it please the court. To answer your 2 questions, Your Honor, at trial, counsel on the July 14th, 2023 date, counsel was very much advocating in her closing that father was fit and that he wanted custody of his child. To my knowledge, there was no proposed order that was filed. And you also asked, Your Honor, about father's living situation, and that can be found in the transcript volume, pages 329 to 331. Father testifies that he lives in New Hampshire, he lives in Georgia. In New Hampshire, he had lived there for a couple years, backtracked, said it was a year, and then said it was a mailing address. So there was a varying addresses provided at that time. Your Honors, father's counsel is not contesting any of the evidence as presented before the juvenile court as being clearly erroneous or that is not enough to terminate father's parental rights. Counsel is only stating that Attorney Z, who is father's fifth attorney during this care and protection case, did not do enough. And Your Honors, here is why counsel is wrong. What Safarian tells us is that the behavior, there's a two-pronged test as to ineffective assistance of counsel. The behavior of counsel fell measurably below that which might be expected from an ordinary fallible lawyer. And two, counsel's conduct was likely deprived the defendant, counsel's conduct has likely deprived the defendant of an otherwise available substantial ground of defense, that the outcome would have been different. Attorney Z was appointed on February 7, 2023, and that is a very important hearing. That hearing was the first day of trial after 13 continuances for 2023. Father at that time spoke up that he could no longer work with his current attorney, Attorney G. He had worked with Attorney G for 2 years. If you go back to that transcript, which you'll find on page 304, during that hearing, the judge was very upset. You can hear her frustration. She knows she has a 6-year case, and she brings father up for a colloquy. Father's proposal at that time was that he could not work with the attorney because he wasn't getting in-person visits, and he wanted to hire private counsel. Attorney Z was not hired that day because the judge also wanted to make sure, give father time to appoint counsel, but she did not want to leave him unrepresented. So she appointed Attorney W. Attorney Z then became the 5th attorney when Attorney W, for some reason, withdrew. In the time that Attorney Z worked on this case, she worked zealously trying to advocate for her client. She reached out to the client early April via letter to his home in Georgia. She contacted him via telephone 7 different times. She requested the DCF file several times, I believe, via email. She received 51 A's and B's, dictation, court investigation reports, the family assessments. She prepared, that allowed her with all that information to strategically prepare for trial. She was able to present father. She had him take the stand. He was able to tell his story. And she also did a very detailed closing. And she did, as counsel said, submitted very detailed motions in limine.
So your argument, in essence, is even if counsel came in on 2 wheels at trial, ultimately the job got done during the trial. And the issue of, is that correct? For
Yes, Your Honor.
And the issue of increased visitation, am I understanding that your position on that is that the judge was well aware of the fact that father's priority was in-person visitation, and that reframing, it wouldn't necessarily have made a difference one way or the other if final trial counsel framed that as a motion, again, given what the judge's awareness already was?
Yes, my understanding was that counsel also reached out to the department to inquire about having in-person visits. But as Your Honors have said, from a period of at least April 2021 to June 2023, there were 22 virtual visits set up. And father didn't have to have an hour visit or a half-hour visit. His own testimony on June 28th during the trial, he said he was very familiar with children. He had actually spent time with a child that had autistic needs, like a child in our case. And therefore, he could come in, show up on time, have a great 10-minute, keep the child active, since he was used to, as he said, working with children, keep the child very active, bring in puppets, bring in stories, do whatever he needed to do, and just be there. The 22 visits in over 2 years, as Your Honors has said, he had 16 visits virtual visits that he did not call DCF, he did not confirm, and he did not show. 5 visits, he confirmed those visits, did not show. So he did 1 visit in over 2 years, and the year prior to that, he also did not have visits. So we're talking about a 3-year span. And the DCF policy, he did not agree with. That is in his testimony in the June 28th trial, that he did not agree that he should have to confirm visits. So he was opposed to that. And whenever the department did set up a visit for a Monday or a Friday, he also disagreed with that and wanted it changed. They tried to accommodate him, but he often did not show up.
Can I
And
ask you a
what's-
question about the trial? Because there was an affidavit submitted from his wife that she would have testified to X, Y, and Z. And did she appear at trial, and or was she not there? Did he
not-
bring her?
She did not appear, Your Honor. She didn't appear on February 7th when he was told that he was going to be going forward with this trial, and she didn't appear on June 28th. And she did file 5 restraining orders, and I believe it was Attorney Z who used that strategic decision that she filed 5 restraining orders in the district court. And in that instance, therefore, Attorney Z would have determined that if she wasn't truthful in this court, how do we know she's going to be truthful here? And very important with Safarian, prong 2. It wouldn't have made a difference. The evidence in this case was overwhelming. There was significant, as my Attorney Price has said, significant criminal history, domestic violence. Of the 11 women that he was involved in, I believe 6 filed restraining orders. He was a defendant on 9 restraining orders. He was indifferent to the child, didn't visit the child. He testified on June 28th. He didn't know her birth date. He didn't know her age. He didn't know what grade she was in at school. He didn't know what her autistic needs were. So he was very indifferent to the child. See, my time is getting close.
Actually, it's up. Once it's ended, it starts going up. So the red light flashing means it's over. So if you have 15 seconds, you want to conclude?
I just want to conclude that this has been a very long case. It's been a 6-year trial. The child was removed in July 2017. Mother did get her back for 3 months. From September 2017, she's been with a very loving family that my child wants to be with. They have taken care of her for 6 years. And we'd also like to ask that there be if it's possible, we certainly know how busy the court is, that there could be a quick decision. You take the 6 years and then you take today. We're at an 8-year time frame for this case. A very long time, and my client is just anxious to move on with their life and have permanency.
Okay.
Thank you.
Thank you. The case is submitted. We are going to take a 15-minute recess, and we'll be back. That clock, they haven't set it back yet. So it's Attorney Krasner, I see you're ready for us.
Always am.
Let me call the case first. It's 25P426, DCF versus mother.
Thank you. May it please the court, I'm Sherry Krasner on behalf of the mother. My client, who lives in Western Massachusetts, is watching the argument on the live stream. Nothing on the civil side of the docket is as consequential as the termination of parental rights. This court, by scheduling every such case for argument, shows just how serious you are about making certain that the lower court is right on the facts and on the law before allowing for the legal relationship between a parent and a child to be forever extinguished. When you do this, you are not finding facts, but you are just making certain that the trial judge made specific and detailed findings that show that she has mastered the record. In this case, it simply is not possible for you to conclude that the judge performed this duty, and for this reason, you must not affirm.
Hold on a sec. We got to start the clock. Thank you. Go ahead.
The judge here heard from 11 witnesses and reviewed 80 exhibits for a case that was filed in 2017 and was tried in 2024. Despite that great amount of time, all those exhibits, all those witnesses, she only made 22 findings of fact, and only 9 of those are regarding mother's purported unfitness.
There are 20, I mean, I know this isn't a battle about the numbers, but there are 22 findings, but the findings could conceivably have been broken out into substantially more than 22 findings. Would you agree with me on that?
I would agree that that could be done, but I don't think it would still answer the question. What we don't know from these findings. We don't even know mother's age. We don't know her educational history, her employment history. Although the judge talks about mother's mental health, she never tells us about any mental health diagnoses, any treatments, any programs that the mother attended. We only hear in very broad generalities about the mother's purported non-compliance with services, but what were those services? What was on mother's action plan? Did she go to therapy? Did she go to domestic violence counseling? Did she regularly meet with a social worker? Did she attend foster care reviews? None of that, nothing that paints a picture of this mother is in the record. We know that she did not comply consistently with random urine screens, but how many did she miss? Why did she miss them? Were they clustered around the time when she gave birth to her 5th child? Again, none of that is clear from the record and shows that the judge didn't pay the close attention to the evidence that she was required.
But I mean, isn't this case a little different because the judge in fact found her fit and returned 2 of the 3 subject children to her? So, so to a great deal, the judge found that she was fit.
Well, but
so the basis of this termination was that this child is different, and that the mother's got her hands full already, but that she can maybe handle those too. And there's a thing about, she's figured out how to deal with domestic violence, and I'm pretty sure that if that came up, she would be able to deal with it with these 2 pretty well-adjusted kids. But throw that 3rd kid into the mix, that kid's going to be severely traumatized by it. I mean, stuff like that.
Specifically addressing the domestic violence issue, this mother was in a stable relationship. There was no evidence on the record that she had been in a violent relationship since 2018. She had a safety plan. So I would have to make a leap to accept the premise of your question, because there's nothing here that suggests that that would be an issue. I am not saying that the judge didn't have reason for concern in this case, but concern is not a substitute for evidence. Chief Justice Blake frequently asks at argument, what's your best case for the proposition that you're arguing? And I would say in this case, it is adoption of Linus that I cite in my brief at 73 Mass Appeals Court 815, a 2008 case, I believe. This would be a challenge for mother to have 3 children with special needs. But again, really focusing in on what is it about mother that would make it not possible for her to parent this particular child. That's what's missing from this case. The 2 other children that were returned do have special needs. They have both medical and mental health needs, and yet the judge doesn't see the difference between those 2 children and the subject child here.
Well, there are some distinctions, right, in the judge's findings. The judge found, for example, that the mother said that she didn't use gummies or THC when there wasn't someone else there to watch the children, but the judge found that if this child was particularly prone to wake up and need reassurance and need it immediately, and that if the child was to go do that and the mother was under the influence, that the mother would be unable to provide for that child. So that's one difference. And the mother also indicated that she had care for all of the children, but the judge found that the time that the mother indicated that the partner could provide care didn't align correctly with the time that the partner said he was working, so that there was no care available for this child who needed stability and predictability going forward. So there were some distinctions. Wouldn't you agree with that?
I would agree that those are the findings the judge made. I would suggest that some of the findings that she made about this particular child were not supported by the record. She talks about the fact that the foster parents had to come to the school multiple times. In fact, the record suggests that the only times that the parents were called to the school for the child were on 2 occasions, and those 2 occasions happened while...
Oh, I'm sorry, I'm just a little confused. Are you saying that there's no qualitative difference between the 3 children?
I'm sorry,
Are you
could
saying that
speak
there's
into the
no
mic,
qualitative difference between the 3 children, that there isn't? Are you saying that they all, that their care essentially is the same, or are they have the same needs? Because I think I think that the record is clear that this child is particularly vulnerable.
All 3 children have special needs. I would concede that the subject child does have more needs than the other 2 children. But one of the needs the court identifies is that taking him out of the home in which he has lived for so many years. But another child had lived in that home for even longer and was taken out, and somehow mother would be able to meet that child's needs but not be able to meet the
I'm sorry,
needs
I thought that of the 3 children, this was the oldest child, and so how the other one had been. How are the other? Because the other one went there first. And
the other one went there immediately from the hospital, and the subject child was in another home for a few years and then moved into the home. So also that bond was being broken between those 2 children who had lived together for a number of years. The judge doesn't seem particularly concerned about that. The subject child had medical needs, that one of those included psoriasis and eczema, and that he needed certain regular baths. One of the children who was returned also had, it was termed as severe psoriasis, so some of the medical needs.
I don't think the qualitative difference, though, was the child's skin conditions. I think the qualitative difference was the child's emotional needs and the fact that it would take hours and multiple people to calm the child when the child was dysregulated, correct?
I would not disagree that he sometimes needed that calming down. I would disagree that the record shows us that it happened on multiple occasions. I don't think that's what the record suggests. And certainly the judge didn't make any particular findings about that. She, again, just talks in these sort of general and vague terms.
Okay. But what do we do, even, so if we were to agree that this child had particular vulnerabilities and needs, what do we do with the finding that the mother does not seem to subscribe to those needs and in fact blames the placement with those needs?
I have two things to say about that. First, this case was filed in 2017, 2 days after this child was born. It went to trial in 2024. Throughout that entire period, mother never had an overnight visit with the child, never had anything other than supervised DCF visits. Again, I know that from my review of the record, the judge doesn't tell us all that, but the mother was never given the opportunity to see if she could she deal with this child in an overnight? Could she deal with this child on a weekend? We simply don't know what her capabilities were. And as far as the blame, that does go to the issue of that the judge makes a very big deal about mother's purported minimization of her poor qualities and an over-exaggeration of her good qualities. And whereas the judge was free to reach that conclusion, she should not have reached it unless she reviewed the entire record. And certainly the psychologist who, for DCF, performed an evaluation of mother back in 2021 said that there were explanations for why mother was so defensive about some of her lesser qualities and tried to exaggerate some of her greater qualities. The psychologist put it in the context of a macro and a micro context, the macro sort of being as a black woman having to face white institutions, and that for this particular woman, all that she had been through, and she gave birth to her fourth child, and she was substance-free. There were no issues at the hospital, no issues with her prenatal care. DCF, 2 days after she comes home from the hospital, shows up at her door with the police and takes that child because of her history. And even though the 51B that's conducted about that child says that was not supported, that child remains in care. So she was, and they take her last child too, even though no issues with the birth of that child, and he gets returned a few weeks later, but she felt so beaten down by the system, and her response to that was to magnify herself. It was really the only way that she could keep dealing with the department after all these years, and the judge the judge turns that around. Instead of saying, wow, this woman could have stopped fighting, she could have just given up. This woman who never had the subject child in her care ever, and she's still fighting, she's still trying to get him, and the judge uses that against her instead of seeing that as the strength and the resilience that this parent does in fact have. So again, no one is suggesting that this child should have just been returned home and that would have been the end of the case. But on the overall record, to suggest that this judge found that this mother could not parent this child, it just doesn't exist in terms of mother's unfitness, and that a careful transition plan with court oversight during the whole time would have better served this parent.
But isn't the question whether it better served the child?
Of course, that's the ultimate question in all of these questions, the best interest of the child, but I'm not sure what he was bonded to these foster parents, that is true, but even the expert that was retained by the child's trial counsel said that he had a secure attachment to his foster parents, the pre-adoptive parents, but that he also had an attachment to his mother. And
I'm not challenging that, and it's apparent from the record that the mother cares about the child, and I don't mean to suggest otherwise.
Right, so the fact that he's never lived with her, he's never spent a night with her, that there still is an attachment certainly suggests that her ability to parent him is possible, and certainly suggested it would be in his best, or not contrary to his best interest to be parented by her, given that attachment that existed between the two of them. I see my time is coming to a close, and if the
And in
panel
fact, we
doesn't
started you
have
a little bit.
questions.
We started late, so I think you've had 15 minutes probably, so if you have anything else you want to finish?
No, I'll rest on my brief. Thank you.
Okay. Thank you.
May it please the court, Jeremy Bayless for the Department of Children and Families. I think my sister provided me with a nice place to start. She asked, what is it about mother that would make her not able to parent this child? And the answer to that question is a combination of this child's specific needs, specifically attachment issues and a secure bond with his parent, with the pre-adoptive family, combined with mother's lack of interest or effort in actually understanding what those needs are. Mother testified that she did not know about his therapy, she knew the diagnosis of the attachment disorder, but she didn't know the specifics therein or how it was dealt with because no one told her. But what the court found, and what was actually the case, was that the department provided her with releases so that she could speak with all of her child's providers, and she simply chose not to do so. So we have a child with serious emotional needs that are specifically related to attachment. When he came into this foster family's care, it took him 2 hours to go to sleep, and a foster parent had to stay with him till he fell asleep. They'd gotten it down to a half hour after 4 years, and they still had to stay till he fell asleep. He just must have fallen asleep faster. He slept with one of his foster parent's shirts over his pillow. This is not the case where there are 3 fungible children, and 2 of them being okay means the 3rd would be. This is very specifically linked to this child's needs. And if the child were removed, the accredited expert testimony was that he would be as if a newborn was placed in the home. He was 7, because of the high level of additional trauma he would receive from that separation. That's not to minimize mother's connection with the child. The court actually acknowledged a great deal of positive information that my sister is arguing because the court returned 2 of the children to mother's care. The court recognized that mother's substance abuse history is concerning, but doesn't quite rise to the level because 2 of the 3 children went home. The DV, her denial of the DV history was concerning, but didn't quite rise to the level on its own. 2 of the 3 children went home.
And I'm
Yes.
catching up with you.
Sorry.
Did the judge make a finding about the mother's lack of interest in the child's diagnosis? Because part of
Yes.
Attorney Krasner's argument is that the judge didn't make enough findings.
I believe that was encompassed in, I want to say 15. It would be cited where that came from is cited in my brief, and I apologize, I don't have it right at the top of my head. But
yeah,
I believe
you'd
that
say
was,
yes, that she did make that
yes,
finding.
that was specific. Mother's engagement with the department and with the child services is in the findings. But I believe that the releases, the fact that the releases were provided to mother for her to reach out to the service providers and that she didn't do that, that is in the transcript.
That's in the transcript, not in the findings.
Yes, not in the findings. But mother's lack of general engagement and understanding is referenced in the findings. That is a byproduct of the way the court chose to structure its findings.
So what about, so just a few of the things that counsel for the mother raises. The finding that the foster parents are frequently called, is frequently 2, or are there more than 2?
So I think that depends on how you look at it. It was 2 times in 3 weeks. I think that's fair to say that was not an error to consider that frequently. And the court's finding did note that this was attributed, the child had been doing well, but there was a change. He was getting to a slightly higher level of academic rigor, slightly less free play, and that was triggering some behaviors in him that was leading to that sort of burst. So while it certainly wasn't the case that it was over the course of 4 years every week the parents were out there, it was the case that right up before trial it was happening. It happened with enough frequency to be noteworthy. and that the foster parents were the ones that had to go and calm him down. And that is considered in conjunction with the fact that when he has meltdowns at home, it requires teamwork of 4 different adults working together to calm him, and the fact that mother has never had to do that.
And I wanted to ask about finding of fact 11, which is also brought up in the mother's brief, is that that's the one where the finding is that the mother is not able to provide the child with the parenting he demands. Her skills and abilities do not arise to the level, and it's based on 3 witnesses, and one of them is Dr. English, who never saw mother with the child. So that's left. That leaves you with the social worker, Geisler, and mother. Does the rest of the evidence bear that out? Or?
It does, because so I think that is a conclusion. Well, again, the structure of the findings would that it were slightly different, but that is a statement that requires information to come from several places. So Dr. English testified to the level of the needs that the child had and would have were he to be further traumatized by the severance of his relationship with the foster family. And then the evidence from the social worker and the rest of the record was addressed to mother's approach to addressing the child's needs, her ability/willingness to attend regularly scheduled appointments. If this child needs therapy, is she going to treat those therapy appointments like she's treating her court-ordered urine screens? So that the pieces of that were coming from different places. It is not the case that the department's expert has to provide expert testimony as to every single piece to get there. And this is, again, as I was saying earlier, this is not to minimize mother's connection with the child. The court expressly recognized that when it found that there was a bond and ordered 6 post-termination visits, which is more than usual in cases where the parent and child is bonded. There was a recognition that this mother was doing better than she had been in the past, and a recognition that she did have a bond with this child who she had never had in her care. But we are in the tragic situation where this is a very emotionally fragile child who has already experienced significant harm because of his 7 years removal from mother's care. And those 7 years weren't all while mother was doing well. Much of that time was specifically due to mother's failings that had not yet been even begun to be addressed. And so while this is not a case where the sole dispositive factor was bond with the foster family, it is certainly further down that line than the average case that we see. Mother might have been able to, and the court found that she was able to provide minimally adequate parenting to 2 of the 3 children. But we have one, the final child, she was not. It would be a grievous harm to this child to remove him from the home where he's lived for 4 years, where he has begun to make progress in addressing and remedying the harm that was done to him because mother was unable to parent him for 7 years. And all of that work would be undone, and he would be significantly harmed if he returned to her care. And mother's testimony demonstrated that she was not equipped to deal with that. And if there are no other questions, I will rest on my brief. Thank you.
Thank you.
Good morning, Your Honors. Attorney William Como representing the child. Your Honors, the mother does not challenge several important findings in this case, which I think are really dispositive. Finding 6, the judge said without his highly structured and predictable routine, can become combative by kicking, biting, spitting, screaming, and throwing himself on the floor. Finding 7, he has an attachment disorder.
And let's try to avoid using the names.
I'm sorry if I did. My apologies. Yeah. My apologies, Your Honor. The child, he has an attachment disorder, separation anxiety, and struggles being away from the foster parents. He needs a lot of sensory input to settle and calm himself. He has a lengthy and complex nighttime routine that is required for him to sleep. Finding 9, in the transcript on page 704, he needs to be made aware of changes in his routine with enough time to process them. Now, Your Honors, take that and compare it with what the mother testified to. Most of the judge's decision, I would argue, really came from the mother's approach to this case and her demeanor on the stand, her lack of forthrightness about her minor substance use history, having used cocaine in the record 5 times and still smoking marijuana or using marijuana products, failing, 85% or not showing up for 85% of all the drug screens that she volunteered to take. This isn't about whether she has a drug issue. This is about whether she has the ability to follow through with a commitment that she has signed up for. This child is a much bigger commitment than the substance use issue that she failed to follow through with. Her inability to acknowledge her faults speaks volumes about her inability, or anticipated inability, to appropriately acknowledge this child's issues and deal with them as she needs to as a parent. My brother has really said much of what needs to be said on this, but just to point out that obviously the issue here is whether this judge abused her discretion. She did not spend a lot of time going over all of the facts in this lengthy trial, absolutely correct, but she didn't need to. The focus here is really this mother's particular ability to deal with this child's particular needs, and on that, I think she hit a home run. Excuse me. This child can't be separated from the foster parents without substantial trauma to him. This mother has no ability to anticipate his needs. My sister said that there was a bond. I believe there was an attachment, perhaps, but the way the bond was described by the expert is someone who can anticipate a child's needs before it becomes a difficult situation. And mother has no ability to do that. Mother's only involvement with this child has been pleasant interactions once a week at a situation where everybody is enjoying themselves. That's not what you need to parent this child. And mother, although it's not her burden, didn't demonstrate that she had the skills, according to what the judge found, in order to successfully do that. So I'd ask you to affirm the decision of the court.
All right. Thank all three of you. Very helpful arguments. Well, the case is submitted, and that will end our session for today. I want to thank court officers and